As your lordship, I beg to mention item number 25 of today's list, my lord.
25.
25, my lord. Actually, I have to file one IA for withdrawal of Wakaratnama. I will be filed during the course of the day, my lord. Let it come on next week.
Item 25, learned counsel. You're for the
I'm for the
petitioner
petitioner, my lord.
that intends to file an IA purpose of withdrawing his power. Cancel is the matter again on.
Lordship, I beg to mention item number 13, Lordship. Waiting for an
30.
1-3. This matter, Lordship, I have taken the consent of the to file my objection in this matter. Next time, Lordship.
The prayer of NCB and with the consent of the other side, release the matter again on.
May I please, Lordship? My lord, I beg to mention item number 24. My lord, in this case, my lord, I have to file a dosti service affidavit, my lord, upon the respondent number 3 and 4, my lord. My lord, 1 week time may be given so that I can file the affidavit in for dosti service, my lord.
Learned counsel for the
Petitioner.
that he requires a week's time to file affidavit trustee service. Is the matter again on.
Highly obliged, my lord.
May I please, Lordship? I beg to mention item number 37 for adjournment because my learned senior counsel, Ash Sharma, he is not in Gauhati in New Delhi for his further treatment and checkup. With the consent from other side-
37.
Yes, my lord. 37.
Inform the other side.
Yes, my lord.
Learned counsel for the
For the respondent.
respondent and with the
In March.
Please, your lordship, I beg to mention item number 31. It's some time to file our substitution petition.
on the prayer of learned counsel. List again on.
3 weeks, your lordship.
May I please, your lordship? I beg to mention item number 48. So, lordship, my senior is out of station. So, lordship.
I am for the petitioner, Lordship. This matter is part here. Your Lordship already heard that whether 15 days period is mandatory or not before filing complaint. That Lordship already heard. I am praying Lordship may fix it this week only, Lordship. Because already your Lordship has heard.
Friday?
Thursday.
Thursday, yes, Thursday.
Please, your lordship. With respect to item number 11, lordship, MSC appeal number 8 of 20, lordship. The concern of the respondent authority, lordship, we adjourn for 3 weeks, lordship. Because there is a pain recovery, lordship, there is no possibility of amicable settlement because matter on there is pain recovery, lordship. So insurance will not go for mediation, lordship. On
Matter of pain recovery, my lord.
on earlier occasion also,
It's
lordship.
not fit for mediation, my lord. And then they were not taking steps on respond number 2, my
We are
lord.
supposed to take steps upon in the correct address or respond number 2, lordship. The Lawazima report, lordship, the steps could not, the service could not be substituted, lordship. Service
Given.
complete. 3 weeks time may be granted, lordship.
Prayer of learned counsel for the appellant is the matter.
Oblige me.
Oblige, lordship.
Regarding item number 38, I am appealing on behalf of S.C. Sharma, senior advocate. My lord may not be taken, my lord. SC Sharma on behalf of respondent, my lord.
30?
38, my lord. I have taken consent of the my petition.
Lordship, I am for the petitioner, Lordship.
38?
38.
Who?
SC Sharma wala senior jury.
Last item also. Is the matter before another bench without me?
Deep level, sir. Please, your lordship. Lordship, I beg to mention item number 16, lordship.
16.
Yeah, 16. The lordship better like to take up this matter because Mr. A.C. Sharma is engaged in this case.
Item 16, list the matter before another bench without me.
May I please, Your Lord.
Solution, maybe.
Page 35, well, 487, earlier your lordship was kind enough to reject it. That is page 35 is the rejection order. Today 68 days, my lord, behind the bar. And delegation of criticizing the judiciary, my lord. But 111, 3 will not apply, my lord. It is not an organized crime, my lord. But a co-acquis has been granted by the Lioness court below. I am placing the
Criticizing judiciary is just one of the minor allegations against you. There are many others.
but other things are probably 111 will not come, my lord.
Page 38, para 10 verse.
She is punished about this lady is punished enough 68 days, my lord.
Yes, PP.
Yes, Lordship, as per the earlier rejection order, Lordship, sufficient materials are there, Lordship.
I think is only length of detention.
Yes, nothing else. Only detention. 68 days completed. Her father came to me and I have cautioned why you have allowed your daughter like this. She's old lady, 46 years old.
But was arrested on 12/20/25 and since then spent 68 days in custody. Here bail application on behalf of the petitioner rejected by this court, order dated 20/01/26. Perusal of the CD. Petitioner admits that in the length of detention of 8 days, detention of the petition be warranted. It is that the co-accused granted bail by the below by order dated 5/2/26, wherein it was observed upon perusal of the CD that considerable progress has been made in the investigation. Full stop. Having regard to the above period of detention, 68 days. Further detention petitioner may not be warranted. Accordingly, the prayer for thousand with 202 it for below, provided that will cooperate with the try to influence, intimidate any of the petition.
CGM Silchar Kachar. Develop.
Please, your lordship.
Yes,
Earlier dismissed by your lordship due to some mistake on my part, lordship, at page 12, lordship, page 12.
yes, what is the case?
The case is the lordship, actually this is a mob violence, lordship. One person died, lordship. I am the resident of particular locality, lordship. In fact, I am not aware of the fact that such things happen, lordship. FIR page 8, lordship. Years old lady, lordship. I'm suffering from some heart disease, lordship. I've annexed that document at page 14, lordship. Medical certificate, lordship. Protect lordships, CD may be called for and I may be protected lordship.
Whereas Decca is your, who is it? Who is Osiris Decca?
Authorized the lordship.
Incident took place in the house of Osiris Decca, is it?
Lordship, and he's neighbor lordship. He's my neighbor lordship.
At this stage, CD may be called for only.
I may protect a lordship because police behind me lordship and I'm a widow lordship. So staying lonely lordship at that resident lordship. Problem lordship.
Of the allegations causing previous injuries by assault may not be, she's a 67-year-old lady, may not be connected. Third learned counsel for the petitioner, LPP. This is an application under so and so. Stated in the FIR that on 5/1/26, when an unknown person tried to enter into the house of one Ozoy Dekaraja, thereafter a commotion took place. The said person was tied up and assaulted by some persons, causing grievous injuries. Subsequently, the said person was found dead. About 50 meters away from the house of the said Dekaraja. It is submitted that the petitioner is only neighbor of the said Dekaraja, said 7-year-old widow has connection with the instant case. A call for the CD. It is provided that in the event of whereas the petitioner so and so shall be bill of rupees 50,000 with one surety, like amount satisfaction of the arresting authority. Appear before the IO within a period of 7 days from today. For the purpose of investigation.
Okay, 10 days lordship. 10 days. But deeply obliged lordship.
23rd lordship.
Yes.
Your Lordship, I am for the appellant insurance company. My name is there, my senior's name is there in the Wakalatnama. However, the file is not with us, Your Lordship, so we need to seek instructions from the company. There was a similar matter, the analogous matter. In that matter also, we have taken some time, Your Lordship.
When is that fixed?
The order was passed on 2nd of February. I was fixed up, listed after 2 weeks.
Submitted by learned counsel presenting the insurance company that the record of the case is not available with her of today. Praise for some time. Seek instructions from the company. It is a similar matter. Ending. You have the number.
MSC Appeal 146 of 2004.
Is the matter along with on give a date. How much time do you want? 2 weeks?
Yep, 2 weeks.
weeks.
In this case, the respondent has died on 8/10/2022. The analogous matter, we have said that.
Any certificate submitted? No.
In that case, we have submitted, Your Lordship, but in this case, we would like to place a record here.
The respondent has submitted that the respondent has already expired. What do you have? Death certificate.
Death certificate.
Places on record a copy of the death certificate. The same on the record. So what do you intend to do now? You have to substitute.
Lordship, first we'll seek instructions if we are appearing, we have to represent the appellant or not, because Your Lordship, 3 names are in the Wakalatnama and the file is not with us. So we first need to clarify who has the file.
What is the date of death?
Your Lordship, it is on 8/10/2022, Your Lordship.
Long ago.
Yes, Lordship.
Then what will remain? Yes.
Your Lordship.
My lord, although service is not complete on respondent number 2, but it may be sent to mediation, my lord. No. Lordship.
Service is not complete means against whom?
Respondent number 2, my lord, I think my lord, owner of the vehicle, my lord. It is only for quantum, my lord. That's why.
Lordship, respondent number 1 has expired on August 20, 2020. Just came to know. We are going to file the substitute.
Then we have to substitute, my lord.
It is submitted by learned counsel for the respondent that the respondent has expired on. When?
After 4 weeks, my lord.
When did he expire?
August 2020.
Sometime in August 2020. Any certificate is there? And the said information has been received by her today. Learned counsel for the petitioner prays for time to submit substitution petition. Prayer is allowed. Place the matter again after 2 weeks on.
Obliged, my lord. Item number 4, my lord, is not fit for mediation, my lord, because they have not insurance policy at all, my lord.
There
is breach of-
record
breach of-
has been received, so kindly fix a date for hearing, my lord, in the matter.
No problem.
The order is already there that this case may not be referred to mediation. Why is it coming in this column again?
LCR has been received, lordship, so
A date may be fixed, my lord.
date for hearing may be fixed, my lord.
Parties are represented, LCR has been received. As reflected in earlier order, the matter is not fit for mediation. Hence, list the matter for hearing on.
Lordship, can it be on 10th of March?
All right.
Obliged, my lord.
none appears as per order of the Lavazima Court dated 4/2/26. It appears that despite several opportunities granted, the appellant has failed to take steps despite previous directions of the court. And thereby the appellant has failed to comply with the orders of this court as well as that of the Lavazima Court, which leads the court to presume that the petitioner and appellant is not interested in pursuing. Is the matter again on Wednesday. Wednesday list could be wrong.
Please, Your Lordship. Lordship, in this case, name of the insurance company has not been shown. So we have to take fresh steps, Lordship. On respondent number 1.
Respondent number 1.
Lordship.
3
Insurance
is not required.
2, 3 are strike of Lordship.
Order of striking off is there already? No.
Appeal is mainly on quantum, Lordship. So
Has any order been passed for striking off? No.
yes, Lordship.
Where?
Last Lavazima.
Lavazima cannot strike off. Court has to strike off.
Lordship, kindly see the order passed by Lavazima on 2/2/26.
It is seen from the order of the Lavazima Court dated 2/2/26 that as per submission of the learned counsel for the appellant, respondent number 3 is not a necessary party. And as such, the name of the said respondent is required to be struck off. In view of the above, the name of respondent number 3 be struck off. The corrections be made in the cause title further submitted by learned counsel that the name of the insurance company shown in the cause list. You are for whom? The appellant is insurance company, no?
Lordship, and for the appellant claimants.
The insurance company has and also prays for time to take steps on the respondent number 1. Hence list the matter again on so and so, showing the name of the insurance company. Petitioner to take steps within 3 days. List again on
I am for the
Yes.
appellant, Your Lordship. The claim petition was dismissed on the ground that rash and negligence not proved, but the driver already faced the trial and admitted that he broke the rule.
Faced the trial and he was convicted.
He is acquitted. Charge sheet submitted against the driver, but he is acquitted.
What about respondents 2 and 3?
Owner and driver, yes,
Not yet served.
not yet served. Yes. Two not yet served.
So are they necessary?
I have asked the client, but he is unable to collect. But because driver is not permanent resident of that place, he changed his residence. In MSCT case is given one address, in criminal case is given addresses. I have not received the correct address. After 2 weeks, you understand, right?
Before service, can we refer to mediation anyway?
No. Company is unable.
Now, how will you collect the address of the driver?
Ask the client. But because the address of that specific case and the trial court, I mean, the criminal case is different. Let me try to take.
Learned counsel for the appellant prays for some time to collect the proper address of the respondent number two
Driver.
driver, so that he can take steps accordingly. Is the matter again on? So
Please, Your Lordship. Notice in respect number, respond number 3 and 4, my lord, are pending, my lord. Lordship, in fact, there is an omission on my part, my lord. I would like to point out, my lord. There is an order dated 26/2022. There is an order for paper publication. So somehow, Lordship, I omitted to do that, my lord. So I'm praying for allowing me to take the steps to paper publication, my lord. For respond number 3 and 4, my lord.
learned counsel for the appellant submits that he could not take steps upon respondent number 3 and 4 by way of paper publication due to oversight, and accordingly plays for some more time. Hence, list the matter again on so and so, by which time petitioner shall submit proof of service paper publication. Interim order passed earlier.
Respondent number 1 and 2, that may be reflected.
Much obliged.
Wait, please, Your Lordship. Lordship, in this case, Lordship, so far as 1, 2, 3, and 5 are concerned, my lord, the service is complete, my lord. 4, we want to strike off, my lord. They are not a necessary party, so they may be struck off, my lord.
The prayer of learned counsel for the appellant.
4 is necessary party, my lord. 4 is owner, my lord.
Owner of the motorcycle has not been, there is no liability on him, Lordship, so can be struck off. My claim, let me.
Is his prerogative. Prayer of learned counsel for the appellant. The name of the respondent number 4 within bracket owner be struck off, as he is not a necessary party according to learned. Post title be corrected accordingly. What about 5?
5 has already appeared, my lord. Office floor dated, my lord, 23/2/21, my lord. 1 to all the rest of the respondents.
Rest of the respondents have already been served as per
Office note 23 to
office-
21.
Office note dated 23 to 21, I think.
Yes, Lord. Now, Lordship, but LCR has not been received in this matter, so reminder for LCR has to go.
LCR is not yet received. To reminder. The matter again on.
I'm okay.
And then
Please, Lordship. My lord, this is my lord, response number, my lord, 1 and 2 is served. Responsibility awaiting for the service report. They also received, but not shown the name. So it is not.
As per office note, you have not taken steps.
My lord, in the meantime, this earlier council is expired company. So I got letter on. I filed in say Wakalatnama first time is state. So I come to know today, sir. I'll take the step against this, my lord.
So and so. Learned
Principal.
counsel enters appearance for the appellant today. As had represented the appellant earlier had fired submitted by learned counsel. As reflected in Lawazima Court Order 3/2/26, steps on respondent number 3 have not been taken. Appellant is directed to in days. A registered post with AD as well as by usual process. Again on
4 weeks. Much.
show the name of the newly engaged counsel for the appellant was list.
Lordship, in this case, I am for the claimant appellant. And we have paid, apart from enhancement, we have paid for settling the liability on the insurer. It was settled on the owner. We are praying for pay and recovery. Perhaps it cannot be settled and 2 insurance companies are involved. LCR is here. It may be fixed for hearing on any convenience. It is here and the parties.
Learned counsel for the petitioner, appellant and learned counsel representing.
On the number 4, your lordship.
And number 4 insurance.
Yes, sir.
Insurance company.
Office.
Record has been received.
Yes,
Record is here.
PCR has already been received. Appears that by way of the impugn order, the liability has been imposed on the owner and the insurance company. It is submitted that there is payment of settlement litigation. Hence, please the matter for hearing on
I'm appearing for respondent number
I plead the lordship. Kindly pass over the matter for time being.
Very pleased, your lordship. Here's the second bail application, alia, my lord, 60. My lord, person were named in the FIR, approached honorable court. According to this honorable court, by order dated 12/7/11/2025, granted 7 accused out of 16. So, PRS bail, it is your lordship order, page 40. It also rejected the PRS bail for next 19 petitioners. 9 petitioners before lordship. You will find FIR is a land dispute arising out of land dispute. Is this FIR nothing but the counterblast of the FIR laws earlier by the daughter-in-law of the accused number 1? Here, when I am approaching new ground, my lord, I projected some new ground in para 6 on medical ground. My lord, petition number 1 is 64 years old. And Joe is 9 petitioners before lordship, but particularly my lord 1, 3, 6, and 8 that I have also enclosed certain medical certificates.
All of them have fallen ill.
My lord.
All of them have fallen ill after objection.
You always find medical certificate, what is all my medical certificate prior to the incident, not fallen ill, my lord. Page 44, my lord. It is not that, my lord, it is after.
Because prior to the incident, it would have been there in the previous bail application.
Yes, my lord, it is, yeah, that was a mistake, my lord.
I have missed the bus.
And so far as the petition number 8, 1, my lord, is 64 years old, my lord. 64 years old, he is suffering from, my lord, serious disorder in his eyes, such as glaucoma, my lord, and macular degeneration, which resulting professional diagnosis and treatment to prevent blindness, my lord. Huh? 30, diabetes and area. 44. He said he is under the petition number 8. He is a student, my lord. He is after completing his high secondary examination, pursuing pharmacy course in Satyendra University, Hyderabad. That I also include his identity card, my lord. Page, my lord. Page 53, my lord. And so far as the petition number 3 is concerned, he met with the accident. Prior to the incident, he met with an accident with a tractor, my lord, suffered serious backache, my lord. That I also include. Page 49. Serious backache in his, my lord. Backbone. As far as the petition numbers, my lord, 6 is concerned, my lord. Police visited his house, having seen his condition, my lord. Police not him, and he was not arrested by the police, my lord. He lost his eyesight. Petition number 6. Having seen his condition, my lord, police refused to arrest him.
Very good. You have no apprehension of arrest.
The petition number 6 is concerned, my lord. That what is the truth that I am revealing, I am submitting before a lawsuit, man. And all the family members directed to this case, you find FIR, my lord, almost 22% name in the FIR. This petition follow, they are all belong to same family members, my lord. And out of, my lord, it's a counterblast of the FIR.
We are not going back on merits. That we have already decided.
Yes, we have already decided, man. 1, 3, my lord, 6 and 8, only for this petitioner, my lord, I am praying for only these 4 petitioners, my lord. 1, 64 years old, my lord. On that day, my lord, he could not visualize the things properly. He was suffering from eye disease, my lord. On that,
Where is the annexure?
well, page 44, page 43 onwards, my lord. Is there no diabetics and my lord? Recently is undergone treatment in Netralaya. We start from page 44, page 43. up to page 47, it is the petition number 1, petition number page 48. Petition number D is concerned, page 49. The doctor clearly says advice apply to LS belt, avoid strong activity and sitting on the and also avoid sitting on the floor. Page 49. Petition number 3, man. Petition number, it is so far the petition number, man, of what is concerned, he's a businessman. That I am simply the issued my lord annex the certificate that he is running in a business. Petition number 6 is concerned, page 52. Petition number 8, minus page 53, my lord.
Yes, Abhinay. In this case, Lordship, there is no any serious illness.
That is what I am trying to find.
I have also tried to see, Lordship,
I am trying to find anything that
all have been on the same day. They have been researched. They are going for some checkup and some prescription, some advice has been given, and on the basis of that, whether this kind of heinous offense can get.
we can get this kind of prescription.
Everyone also, and interestingly, all went to the same hospital. Everyone, maybe Lordship, that they may go, Lordship. Whether there is any seriousness or serious illness that.
All right, call for the CD.
So a CD we have received, Lordship.
Received.
We have received.
Okay, then
There
give
is
it.
nothing new. I may say.
Whatever he blooded to be submitted, that is not practically truth, my lord. They are suffering, my lord. Yeah. Not that this medical, maybe I may be wrong, my lord, but these medical certificates are not wrong, my lord. They are regularly, my lord, visiting the downtown hospital, Netralaya, initially Mongoldo Civil Hospital. All right, my lord.
All right, Chambal. TPC council. And appears list again on Wednesday. Okay, next. Wednesday.
May please, Your Lordship. My Lord, after my Lord, substitution of the my Lord legal heirs of appellant number 2 and 3, my Lord, I have submitted the amended cost title, my Lord. So far, the my Lord, service is concerned, my Lord, in the substitution application along with my Lord, condonation of delay and abatement, my Lord. That service upon the respondents are complete. But in the appeal, my Lord, Lordship will find the office Lawazima court order dated 1/3/2021, my Lord. Flag, yellow flag, mark. That respondent number 124 has already appeared, my Lord. 4, 5, and 6 are the my Lord brothers.
Yes, so you're supposed to take steps on respondent number 5.
Yes, 5, my Lord, that in the, my Lord, the IA that has been completed, but in the RSA it has not been reflected. So may I pray, my Lord, that the matter may be, because the, so far the
IA is disposed of.
IA disposed of substitution allowed.
He
my Lord.
appeared there.
My Lord, the, not appeared, but service complete.
Service complete.
My Lord. So may I pray that matter may be placed before the Lawazima court, because there is no report as regards the service of other respondents. My Lord, 9 to 13.
So there are others as well.
Yes. One to 4 appeared. 5, my Lord, is the brother of the 4. 5, 4, 5, and 6 are the brothers. 4 appeared, my Lord, they or 2, my Lord.
What is the report with regard to the remaining one after 5?
My Lord, there is no report, my Lord. I have checked it, my Lord. Let the matter be placed before the Lawazima courts, my Lord.
Learned counsel for the appellant and learned counsel for respondents.
1, 2, and 3, Your Lordship.
1, 2, and 3. Here's that and number 4 has also been served. 4.
4, my Lord, not, yes, 4 served appeared, my Lord. As per Lawazima courts, is the 1/3/21.
Respondent number 5, have you taken the steps?
My Lord, taken in the RSA, my Lord, because since, my Lord, we have been newly engaged, my Lord. So, my Lord, in the IA, my Lord, we have taken steps. And after
It's all right, that is over now.
my Lord, that's it. Matter be placed before the Lawazima court.
Steps are yet to be taken on respondent number 5, as counsel has been newly engaged. As regards service on the remaining respondents, mention regarding the same in the office note. Place the matter before the Lawazima court.
Obliged.
Please, Lordship. Here in this case, Lordship, respondent number 2 expired, Lordship. Though we have been allowed some time for filing appropriate application, but the respondent number is from Rajasthan, Lordship. We could not collect the details of the legal years. So we need some more time, Lordship. And so far as respondent number 3 is concerned, we also could not collect the correct address. So we need some time also. And respondent number 4 is concerned, we'll take steps.
Learned counsel for the petitioner, it is submitted that steps could not be taken on respondent number 2 the legal heirs of respondent number 2 after substitution, as they are residents of Rajasthan and their address could not be collected till date. Further, the proper address of respondent number 3 also could not be collected till date. Accordingly, prayer is made for further time. We can't go on indefinitely. You either
Lordship,
find it
Lordship, that is,
by next date.
Lordship, problem is that the respondent two is from Rajasthan. So we are trying our best, Lordship. Further 4 weeks time may be granted, Lordship.
The matter after 4 weeks on. So and so.
Yes, Lordship.
Lordship, the appellant and the respondent have filed an affidavit which is flag marked as X. They want to compromise, settle the matter out of court, and they've entered into memorandum. So this matter may be closed in terms of the settlements which have been entered into by the parties. Is marked as X on the 27th of January 2026.
Had heard learned counsel for the petitioner as well as for the appellant as well as counsel for the respondent. There is the joint petition filed on behalf of the parties for withdrawal of the present RFA, as the parties have settled the matter by way of deed of settlement dated 27/1/2026. Peruse the same, and heard hearing learned counsel, the matter stands closed on the terms and conditions of settlement.
Much obliged.
Your Lordship. Case Lordship, for substitution, we have earlier filed one composite application. Thereafter, an objection was raised, Lordship. Thereafter, we have filed one condonation application and abatement application also. Those two applications are not before your Lordship, but from online I have checked, those were already numbered. IA civil number 258/2026 and IA civil number 259/2026. As per office note.
The first orders are to be passed on those IAs.
Lordship may kindly direct registry to list those IAs, Lordship, so that the
Learned
substitute
counsel for the petitioner.
one can be completed.
Learned counsel for the respondents. Appears that the petitioner has filed IA number
258/2026 and 259/2026.
but the same are not tagged along with the case. Registry is directed to list this matter again along with the aforesaid 2 IAs. List the matter.
Lordship, day after tomorrow also. The FAO, there is an interim, Lordship. Since 2017, status quo was granted.
Here to continue till the next date of listing.
Deeply applies, Lordship.
Lordship, in this case, I'm appearing for the appellant insurance company. And as per the office note, Your Lordship, R2 has been served, whereas steps, multiple times we have taken steps upon R1 and R3, but the service has not been complete upon them. Your Lordship, in the delay condonation petition also, we were required to take steps for newspaper publication upon them. Only after that, the service was complete. As such, Your Lordship, we may be permitted to take newspaper substituted service upon R1 and R3. And the appeal has already been admitted, Your Lordship.
Appeal has,
Already been admitted.
last order does not reflect so.
Lordship, I had ordered it 14/7/2017.
Order we have here is of 12/6/17.
Lordship, I have a copy of the order.
That way, 9 12 আছে আর কত? আপনি বলেছেন learned counsel for the appellant hears that the by order dated was the date of the order
14/7/2017.
7/2000. The appeal has already been admitted. The following substantial questions of law. Copy from here, okay? This 2, 3, okay. Submitted that steps have been taken on several occasions. The residence, but this is not yet.
Your Lordship, it's not complete on R1 and R3. R2 is served.
R2 is served. It for substituted service by way of paper. Here is the record. The prayer is allowed. Petitioner shall take steps by publication in Earlier in one Assamese, one English daily.
Yes, Your Lordship.
One local, one English daily newspaper. The matter again on
4 weeks time may be given. Much honest, Lordship.
you are entering appearance newly.
Lordship.
Any pending IA?
Pending IA for my lord substitution, my lord, 1614. And there's a delay, my lord.
There are three
So-
miss cases.
16
One is substitution, one is delay. What is the third one?
setting aside, my lord, abatement.
So we first have to take up the substitution.
Delay, my lord.
Delay in filing the substitution.
First delay, my lord, date may be fixed for delay in filing the appeal, my lord. Petition. A date will be fixed.
1614 is substitution or delay.
Delay.
1614
delay. my lord.
Delay.
And
1613 is for substitution.
substitution.
1615 for.
Okay, in the delay one, last order is none appears, and today you have appeared.
Earlier set of advocates, my lord, they withdrawn their Bokalat Nama, my lord. Thereafter, we have
Delay, you have filed any objection?
We have filed an objection in delay. Okay, there may be date may be fixed for hearing on delay, my lord.
How many days delay?
467 days, my lord. 467 days.
They claim no knowledge. How can you prove they have knowledge? They said it was their father or husband or whoever they filed revision. We had no idea about it.
The IA 1614 is missing. That date may be
It is missing.
petition of IA 1614. Not in my file, my lord. That is why I am.
The petition.
Copy of the petition is not with me, my lord. I thought that may be fixed for my lord.
Right, heard learned counsel for the petitioner. You write in the IA 1614. Counsel for the respondent submits that the may relates to continuation of delay wherein an objection has already been filed. Hence, list the IA for hearing on the short date.
All right.
Right, please, your lordship. My lord, I have taken steps for service of notice upon respondent number 1A Roman 1 and Roman A 1A Roman 3. But it is reflected that they are not found. Door is closed and the local people said that they are residing in Calcutta. But already I have taken steps for Calcutta, not found.
You are for whom?
I am for, actually kindly see the cost title of the memo of appeal. There is a mistake in numbering. I am 1B and 1C. Second 1B, 1C.
Is Shamiran Chakravarti and Srimati Binapani
And
Chakravarti.
Binapani Chakravarti.
It is 1A Roman 1. First one is Aruna Chakravarti.
Whoever you are now you have to take steps on the new addresses.
New addresses, my lord, what happened? They have filed one CRP, civil revision petition against interlocutory order. In that petition, my lord, I have taken the new address collected and step taken. But it is reflected in the office note that someone told that they are residing now at Calcutta. Already I have taken Calcutta. So paper publication is required, my lord, in this case. There is several times I have taken steps.
When was that that civil revision filed? From where you got the address?
Revision, my lord, revision petition number 296 of 2023. That has been disposed of later on. My learned friend.
That was address of 2023.
Yes.
Now it may have changed.
Same address, my lord. I have taken steps for service of notice upon respondent.
What was the place? That place?
At that time, my lord, this is Calcutta.
No, if you have taken steps in the Calcutta address already.
Yes. Thereafter, my lord, I have taken steps.
What is the meaning of this report then? That they are no longer residing here, they are residing in Calcutta. Huh?
This all pending case, my lord. 82.
Earlier process server's report was not found as respondent is residing in Guwahati. Now, not found as respondent is residing in Kolkata. When notice goes to Kolkata, he is residing in Guwahati. When notice goes to
My
Guwahati,
information, I am for Somiran Chakraborty and Binapani Chakraborty. I have taken information that wife and one son presently residing at Kolkata and another son that is number 1C1. He is practicing in Guwahati as an advocate.
That is,
And
my friend is now telling all this, my lord.
no, that information already they have, my lord.
If it is, then I take certain incorrect address from my learned friend.
already you catch hold of him then, if he is practicing here.
Yeah.
My lord, then I.
And you find the address of them, the others from him himself.
From the advocate, he can find out.
What is his name? Respondent?
My lord, exact address I will provide, my lord, him through my. I will take address of the respondent number 1, 2, and 3 through my.
Well,
1A, 1C, and
Their numbering is.
my lord, 1A, Roman 1, within bracket Roman 1. That is the
Numbering
correct-
is also defective in cost title.
No.
So by name, it may be reflected. Otherwise, it will be.
yes,
There is reflecting in the letter.
yes, hard learned counsel for the appellant. And learned counsel representing respondent number. You are responding
Somiran Chakraborty and Binapani Chakraborty.
respondents Samiran Chakraborty and Binapani Chakraborty. Submitted by learned counsel. The said to respondents that he will supply the address of the unserved respondents, that is, give their names.
Timothy Oruna Chakravarti. Number 1A, Roman 1. And Sri Shubhrangshu Chakravarti. Number 1B, Roman 2.
Take the cost title and put the numbers also in the.
Then Sri Snehangshu Chakravarti. 1A within bracket Roman 3.
Same may be done within a period of 7 days from to. Thereafter, the appellant will take immediate steps within another 3 days upon the said.
One thing, my lord, I shall have to clear before your lordship. 1B within bracket Roman CC Shubhrangshu Chakravarti already refused to accept. And there is a report, my lord, that has been accepted. Refused to accept.
That is already accepted. The service is complete.
Complete, man.
Service is complete in respect of respondent number.
Shubhrangshu Chakravarti.
Chakraborty within bracket. Just again on.
Obliged, your lordship.
None appears. As per Lavazima Court order dated 12/11/25, time was granted to the appellants to take fresh steps for issuance of notice to respondents number 5, 8, and 15. And the event of failure to do so, the matter is to be placed before the court. Accordingly, the matter has been placed before the court today. Indicating hereby that no steps have been taken. Placed again on Wednesday.
May it please your lordship. Your lordship, in this matter, respondent number 7 steps is not complete, but he's a necessary party. And we have already taken steps upon him since 2019, numerous times. So now only one option is left, your lordship.
Last order, as per last order, you have to take steps by dusty service.
Yes, your lordship, we even tried that. But there is no cooperation from the insurance company. I have the intimation letter.
Respondent is insurance company.
No, your lordship, the appellant, we are for the insurance company. Respondent is the owner of the vehicle.
Then you should have filed an affidavit stating that.
Okay, your lordship will file an affidavit. Kindly grant us 2 weeks' time.
Learned counsel for the appellant insurance company submits that pursuant to order dated 5/2/25, the appellant attempted to effect dusty service, but the same could not be done due to non-cooperation of the appellant directed to file an affidavit of the aforesaid facts. The matter again on.
That's all.
May I please your lordship? We are waiting for some instruction from the insurance company to take steps upon respondent number 3.
Respondent number 3 is dead, it seems.
Yes, yes, your lordship.
So what instruction is required? You have to substitute. Learned counsel for the appellant. It appears from the record that the respondent number 3 has already expired. But till date, no application for substitution has been submitted by the appellant.
Lordship, kindly grant us some more time to file the
Praise for further time to submit appropriate application. The last chance. Release the matter on after 2 weeks. Okay.
Highly obliged, Your Lordship.
Yes, as for office number 2 to 26, the LCI has come and appeal is already admitted.
Is ready for final hearing.
Final hearing.
Lordship, I am appearing for respondent number 2, Jagadish Thapuria.
Which one?
One is actually, they are the successors of the original landlord, from whom defendant number 2, respondent number 2 purchased the property, where my land friend's tenanted premises is situated.
Already,
Have they appeared or not?
not appeared because on the last occasion it was struck out by the court.
Third learned counsel for the appellant and learned counsel for respondent number 2. Name of respondent number 1 has already been struck out. PRS called for has also been received. And is the matter for hearing.
A date may be fixed, Lordship.
Your Honor, there is a stay, interim may be continued.
A date may be fixed after Bihu vacation, maybe in the month of April, Lordship. The month of after Bihu vacation. 21 April.
I will be not there.
After a few days.
Maybe in the month of May.
May.
Why so long?
Lordship, apni.
No, we fix any date. The last part of April or the first week of May.
28 April.
This is interim order, it may be continued.
28 April. Obliged, Lordship.
Agent. All right, none appears. Reflected in the order dated 6/9/19 that the petitioner had undertaken to deposit an amount of rupees 5,000 within 1 week. However, the court has not been apprised whether such deposit has been made. This civil revision petition has been referred against an order dated 29/3/19 passed by the learned additional district judge Bojali in case number 5 of 2018 arising out of TS within bracket capital M number 66 of 2013. Challenging the award of a interim maintenance amount of rupees 4,000 per month. The respondent wife. The brief facts of the case are as follows. Page 24. Dated 29/3/19. The learned court below having regard to the provisions of section 24 of the Hindu Marriage Act 1955 and also having regard to the fact that the petitioner was at that time working as executive engineer PWD roads department with a monthly salary of rupees 40,000, allowed sum of rupees 4,000 per month as interim maintenance till disposal of the divorce proceedings in titles TS within bracket M66 of 2013. Since the passing of the order, another 6 years have passed. In the meantime, the salary of the petitioner would also have increased due to pay revisions. Sarah, having perused the grounds stated in the petition and reasons reflected in the impugned order for grant of the maintenance award amount of rupees 4,000 per month from, I do not find any infirmity therein. Calling for interference by court. Revision, civil revision petition. Considering the above, the petition stands dismissed, no cost.
If this item number 46, your lordship.
46.
Your lordship.
Yes.
This item, your lordship, it is fixed for hearing. So between time, actually, I could not come to mention. So I have some problem, your lordship. It may not be taken up today. The next week or thereafter, your lordship.
You're for petitioner side or?
I'm for the appellant, your lordship. I have taken the consent of Jen Chayawala, your lordship.
Yes, early learned counsel for the appellant with the consent of the other. Place for adjournment. The matter again. One, you had 2 weeks.
পিছত দিব পাৰি নেকি স্যার? অলপ পিছত দিব পাৰি নেকি আৰু? Lordship, this March 18 year lordship, I have some problem related to after 21.
End of March.
After 21st. March. 24. What happened?
Your lordship, in item number 33, there is an office note that we have not taken step yet, lordship. As per Lodima court's order, earlier we have taken step. Lordship, other respondents were appearing, some engaged counsel were appearing on the last occasion, so we have not taken step. There is
How many respondents are there?
1 to 8, lordship. 1 to 9. 9 also appeared by Mr. N. Alam earlier. He is absent, so lordship may give some time to take step, lordship. As per office note dated 18/9/2025.
18 or 19?
Office note, lordship.
Yes.
By Loajima Court order dated 11/2/2025, the appellants were directed to take fresh step for service of notice upon respondent number 1 to 8 by registered post with AD as well as by usual process within 7 days from the date of the order. But no such steps have been received by the section till date. So I am praying before your lordship to grant liberty to take step, but now speed post, lordship. That order to be modified.
Here was the order of Lawazima Court dated 19/9/25.
To take step on respondent number 1 to 8 by registered post AD as well as
Whereby
usual.
petitioner appellants were granted time to take steps on respondent numbers 1 to 8 by registered post with AD. However, it appears that steps have not been taken. Learned counsel for the appellant prays for further 7 days time to take steps by registered post on the aforesaid respondent. Is the matter.
After 4 weeks any date, Lord. Complete the service on the respondent, it will take at least 4.
After 1 week, he place it before Lavazima court. Is the matter before the Lavazima court after 1 week.
Obliged, Lordship.
Give a date. None appears on call. It appears from the record that on the previous 2 dates also, none had appeared for the petitioner, and no steps have been taken for substitution of the sole respondent who has expired. Hence, the petition stands dismissed. Yes.
I'm paying for the file Vakalama for the on behalf of the legal heirs, my lord. Lordship in the MFA and the miscellaneous substituted till now. The two of the IAs and names have been
This in the IA, it has been substituted already.
Lordship in two IAs. In the main appeal, my lord, MFA 63 of 2014, MC 3597 of 2014 names have not been substituted.
What is the IA about?
IA, Lordship, I think. Over to the Lordship. For the purpose.
None appears for the applicant on call. It appears from the record date on the previous date also none had appeared. for the applicant on call. This IA has been preferred seeking condonation of delay in filing the accompanying substitution application for substituting the sole respondent stroke plaintiff who expired on 3rd October 2018. IA stands dismissed for non-prosecution. Consequently, the remaining IS as well as the yes. Same order. Six. Yes, we will go there. Okay, order to. Just one moment.
One.
कोशिश कर लिए होगा इनसे
I got ready to do is on. পিটিশনাৰৰ নামটো শ্ব' কৰা নাই ক'ত নামটো উইথড্ৰ কৰিছো এতিয়া আছে মহন্তক বিদ্ৰন্দা ৱাকালত নামা তাতে তেওঁ পিটিশনাৰৰ আছে দেখুৱাই নাই সেইটো অৰ্ডাৰ and appears for the petitioner. It appears that earlier counsel Mr. P. Mohant withdrawn from the case. Name of newly engaged counsel has not been detected. Let me check kori lobosun notun reflect kora ase. The counsels who have newly entered events have not been detected in the cause list. The matter again on so and so. Showing the name of the newly engaged counsel. Item I read to 36 to show করে করে আছিল নহয় তেওঁটো Please the matter on কেটে দিছিল 7 March showing the name of newly engaged counsel in the cause list.
It is. My lord, it's a earlier rejected bail, my lord. Lordship have a look at page 43, my lord, the rejection order, my lord. Page 43, my lord. I'm on a very limited, my lord, ground, my lord. Paragraph 9, my lord, page 43, my lord. I have perused the W2 message dated so and so and the date of arrest, wherein the grounds of arrest were clearly discernible. The said W2 message is addressed to is so and so of Thawbal, Manipur from so and so. In the said W2 message, a request has been made to inform the family guardian of the above mentioned accused person regarding the arrest and grounds of arrest. Although there is no receipt of acknowledgement of the said W2 message available on the record, or any return W2 message indicating service of the said notice. It appears that just 2 days later, that is so and so, Wakalatnama was filed by the private counsel on behalf of the accused person with prima facie indicates receipt of W2 message. The accused persons were also represented by the learned LADC on the date of production and subsequently as well, my lord. Now your lordship will turn to, my lord, page 45, my lord, that is paragraph 13, my lord. In lordship got it, my lord. In state of Karnataka versus Darshan so and so reported in so and so, in account of the decision in Vihan Kumar has held that while section 50 of CRPC is mandatory, the constitutional judicial approach has been to adopt a prejudice-oriented test when examining the alleged procedural lapse. The mere absence of written grounds does not ipso facto render the arrest illegal unless it results in demonstrable prejudice or denial of fair opportunities to defend. The principle would be undoubtedly extend to section 50A of the CRPC and section 58 of the BNSS as well, madam. My lord, my contention before your lordship, my lordship, my lord, kindly have a look of the Constitution of India, my lord, Article 21, my lord.
Yes, read you.
My lord, no person shall be deprived of his life or personal liberty except according to the procedure established by law. So my personal liberty cannot be curtailed, my lord, without following the, my lord, the procedure established by law. So section 48, my lord, in the BNSS, my lord, it provides that a notice should be served to the family members. So in the instant case, my lord, I have not received, my family member had not received any notice whatsoever, my lord. So section Article 21 clearly states, my lord, no person shall be deprived of his life or personal liberty except according to the procedure established by law. So in the instant case, my lord, all those W2 message has been issued and sent, my lord.
But it was the finding of the court that you must have received a notice.
No, my lord. Now, my lord, the second point, my lord, which your lordship will see, my lord, that is the, my lord, paragraph 13, my lord. The mere absence of written ground does not ipso facto render the arrest illegal unless it results in demonstration, prejudice, or denial of fair opportunity to defend. So the apex court, my lord, of the co-equal bench, my lord. This is also division bench, my lord, and the Bihan Kumar is also division bench. Now, in that circumstances, my lord, which case law will be followed, my lord? Whether Bihan Kumar will be followed absolutely, my lord, or this, my lord, this Darshan's case, my lord. Here, my lord, the similar point arose before the division bench of this court, my lord. Can I place the judgment, my lord, of our court, my lord? এখন আবার
NX করা আছে।
paragraph 15 for a once, my lord, in that judgment, my lord.
Yes.
Paragraph 15 of the judgment, my lord. And lordship may kindly have, because my lord, I had only one copy, my lord, that's why.
Yeah, earlier is to be followed. That is the.
Vihan Kumar in toto has to be followed, my lord. So the judgment which was passed in my lord Darshan's case, my lord, it says, my lord, ipso facto, my lord, the word is that, my lord, written ground does not ipso facto render the arrest illegal, my lord. So if we go by the
But it is the Supreme Court itself which, after taking into consideration, Vihan Kumar has passed this order.
Yes, my lord.
How can we say no?
No, but my lord, in Darshan's case, my lord, it says, my lord, the mere absence of written ground does not ipso facto render the arrest illegal.
That is how the apex court has interpreted its
Yes.
own earlier order.
Yes, my lord. Now
It has referred to Vihan Kumar.
My lord, this Darshan case is after Vihan Kumar.
Yes.
Yeah, after Vihan.
In Darshan, after discussing Vihan Kumar,
Yes, my lord.
without dissenting from it,
Yes, my lord.
putting its seal of approval on Vihan Kumar, has said this.
Right.
How can we say otherwise?
That's why, my lord, our division bench judgment, my lord, there is a National Investigating Agency, my lord. The division bench has held, my lord, that the earlier judgment will follow, my lord.
And that is in case of it has referred to that insurance company case.
Yes, my lord.
And said in case of a difference of opinion, earlier is to be followed.
Yes, my lord. In that case also same, my lord.
But how can you say it is now a difference of
My lord,
opinion? Because it has discussed Vihan Kumar.
That the division bench judgment is also, my lord, section is with regard to section 48, my lord. In regard to section 48, my lord. And the second point, my lord, which that a part your lordship will look into, my lord. That is my
But
submission, my lord.
apart from that, as reflected, there is a finding of the court that
from
prima facie indicates receipt of the WT message. Last 3 lines.
But my lord, I have gone through the record, my lord. It is not there, my lord. Maybe with all respect, my lord, let the PP go through the record fairly, my lord. The lordship may fix a date day after tomorrow or something.
All right.
We will also.
I think it was pointed out by the PP himself.
Yes, my lord. That's why.
I have answered, lordship. I have also flag marked it, lordship. Regarding WT message, lordship, but lordship, apart from that, lordship had already mentioned in earlier order. This is third petition.
Yes, third petition.
The first bail rejection order, lordship had mentioned it, lordship, that lordship, he was arrested on 30/7/2025. On 2/8/2025, the counsel for the petitioner has filed an application before the Honorable Judicial Magistrate seeking permission to meet the accused person in jail. And that has been allowed on 11/8. That has been fully mentioned and fully mentioned in the Lordship's order, Lordship. So, Lordship, and that today also I have flag marked it, Lordship.
That means he was intimated by family members only.
He was they came to know. And apart from that, lordship, one more issue, lordship, whether earlier this court has passed an order deciding entire issue 47, 48, entire issue, lordship has decided the issue.
No, I am not.
This court
I am not. It's not completed. I have not completed. I am just. My contention is the my lord. I am seeking to Article 21 of the Constitution. Article 21 of the Constitution says, my lord, the procedure which has been established by law should be followed.
And we have found that it has been followed.
That's why I have to go through.
Finding of fact.
In the instant case, suppose for a case, me with my wife, I am there, my lord. I have committed a crime. My wife have seen it. But the law says that the notice has to be given to my wife. It has to be given, my lord. So in India, my lord, so far our...
That is what we have said, it was given. You have received a notice. That is why you could engage the council.
No, I have not received the notice, my lord.
Then how could you?
Well, that is clear, my lord. If I have received the notice, there should be an acknowledgement, my lord.
Acknowledgement need not be by way of any specific manner. Has
No,
it
no,
been
my
laid-
lord, that
has
cannot
it
be,
been
my
laid
lord.
down in the law in what manner the acknowledgement should be there?
My lord, one thing is there the grounds of the arrest.
By
should be, my lord.
conduct itself, acknowledgement can be inferred.
That I have to go through it, my lord, from the record, my lord, whether I have put any signature and whether it was given to me, my lord, or not. And second point, my lord, was a very, I'm not saying a weak,
Right, if you want to go through, no point in arguing any further today.
my lord.
Yes.
Can it be day after tomorrow, any day this week, my lord?
Whenever you want.
শুক্রবারে দিতে হবে? On 16, my lord, 16.
16th of
I will stick to that submission also, that whether after passing an
17 of-
order passed by this honorable court, whether that can be again reviewed by this court in a bail application.
My lord,
That-
bail application can be filed at any stage, my lord. That my
That
friend
can be
should know.
sent, but that
You
but
cannot- you
not
cannot
on-
stop
not
me.
not on the same ground also.
My lord, can I
This is
go
also
through the
established.
record, my lord? My lord, one, that judgment, দিয়ে দিবো, okay? Judgment আছে।
Yes, yes, give it back to him. He has only one copy.
I'll make up for it.
Really?
7.
59.
Yes.
Lordship, I am appearing on behalf of the appellant. Steps have been taken upon respondent 2 by Dusty Service, and the notice has been given to the company, but the service has not been received back yet.
File an affidavit stating that company has refused to accept the notice. You are for?
I'm for the respondent number 1.
Who? Who is it?
Claim
Eh?
in injurement.
You are for the insurance company.
Yes, my lordship.
What do you mean company has not received?
No, we have given the notice to the company
Hmm.
for Dusty Service, but the service has not been completed or we have not received it back yet. They have not informed us.
Not come to us complaining about your client.
Take some more time for on record.
Third learned counsel for the appellant and learned counsel for the. And only one respondent?
Only one respondent, madam.
One. Okay.
One number 2 is the owner of the vehicle, madam.
Affidavit regarding notice upon respondent number 2 through Dusty mode has not been received back. Again after. On. It. Okay, make it 4 weeks. Insurance company, they won't.
Obligation.
It be please your lordship. Lordship, as per office note dated 23/6/2025, service is not completed upon respondent number 2. Lordship, but Mrs. Debbie ma'am suppose appeared.
I am appearing for respondent number 2, lordship.
The service is complete.
Complete.
Lordship, matter may be fixed for hearing after 4 weeks.
Here is also received. Yes. The petitioner and learned for the respondents. PCR has been received, matter is ready for Hearing, please the matter for hearing on.
Obliged, your lordship. Obliged. Uh, Same prayer, my lordship. Lordship, as per office note dated 4/8/2025, service not completed upon respondent number 3. Lordship, may allow to take fresh steps upon respondent number 3.
3 or 4? What happened to 4?
3. Sorry, lordship. Respondent number 4. Container Corporation of India Limited.
As well as 4, I think you haven't taken steps on 3, have you? Got to go. You have given a fresh address.
Lordship, may allow to take such steps upon respondent number 4 by Dusty service.
Respondent number 4.
Container Corporation of India Limited, Eastern Regional Office, Duckbag House, 5th floor, Shakespeare Sarani, Kolkata 70017, West Bengal.
Are you sure?
Yes, lordship.
There is no respondent number 4 in the cause title. That is respondent number 3.
Yes, lordship.
But yes. Kawajima says new address has been given, but this is appears to be the same address. Duckbag House, 5th floor, 41, Shakespeare Saroni, Kolkata. Given a new address now. It was reflected as respondent number 4. There is no respondent number 4 here. Upon perusal of the Hard Learned Counsel for the yes, from a perusal of the Lawazima court order dated 6/10/23 that the petitioner was asked to take steps that the petitioner that the appellant had submitted a new address of the respondent number 3 and was directed to file appropriate application for correction of the cause title. However, upon a perusal of the cause title, the address of the respondent number 3 one and the same as that reflected in the Lawazima court order. Hence, no order IA is required to submitted. It is counsel for the appellant place for some more time to take steps on the respondent number 3. Accordingly, appellant is directed to take steps by speed post respondent number 3 within 3 days from today. List the matter again on.
Oblige, your lordship.
42.
Lordship, this case may kindly fix the next Lok Adalat, Lordship.
Lok Adalat. Has any date come?
14/3.
14/3. The prayer of learned counsel for
Maybe mediation,
No,
for mediation.
for Lok Adalat, Lordship, it is.
Okay, then we'll see.
If it is Lok Adalat, then it will be 114, then it will be Lok Adalat.
Yes, Lord.
From the company.
The same thing, but after that we'll see.
Yes, my lord.
The prayer of learned counsel for both sides place the matter before the
Next ensuing Lok.
Lok Adalat to be held on 14/3.
Hey, please, your lordship, this I is for an passing of for an with a prayer to take paper with a prayer to take steps upon the respondent one by paper publication, my lord.
Earlier steps were taken in usual
Earlier
course.
steps were taken, but but it could not be served. That notice could not be served as such. No such person was found in the address, my lord. And we could not trace out the new address. So
IA 1865. This IA has been filed, giving permission to take steps by way of substituted service by way of paper publication. It is stated herein that steps upon the respondent number 1 could not be served from office note dated 20/08/24. That notice could not be served as no such person was found in the address. And it is also stated that the applicant could not trace out the new address, the respondent number 1. Having regard to the above, substituted service is allowed by way of paper publication. Where was the address?
address was at Shunitpur, my lord. District Shunitpur. Post office Dhekera Jili.
The publication be made in 2 local newspapers, one being in English and another being another Assamese. Just again on
Lordship, may I please? I have filed 3 IEs. IE number 3766 is for the condemnation of delay of in filing application for substitution of LRs. And I would like to I want to make one submission that actual delay is of 2625 days. But inadvertently, it was like written by me in the application. It's 2743. So I request this court to allow me to correct the number of delays.
counsel for the
Along with that, kindly issue the notice to the parties.
3766. Learned counsel for the submitted that the number of days of delay is how much?
Actually, it's 2625.
625 days. But inadvertently, the figure 2743 has been.
Kindly allow me to correct it by handwritten.
Petitioner applicant is permitted to correct the same by hand.
And I also request to issue the notice to the opposite parties.
Many opposite parties are there? Only two.
There are two legal heirs.
Parties. Steps be taken by speed post with AD. 3 days. Again on.
Obliged.
May it please your lordship, the petition has been filed for striking of the name of appellant number 2 from the area of appellants in the MEC case number 478 of 2019, as the appellant number 2 has expired on 15/11/2019. The Gauhati certificate is on record. I pray that the name of the appellant number 2 be strike off and matter may kindly be listed for further hearing.
Yarun Began.
Yes, your lordship.
IA 61 of 25. IA has been filed for striking of the name of the appellant number 2, Yarun Begum, expired on 15/11/19. Of the certificate issued by the Gauhati. Yes.
I'm appearing for respondent number 3 and 5.
Third Learned Council. The name of the appellant number 2, Yarun Begum, be cause title of the connected appeal. Like the cause title according. Is the matter for any other IA is there? No. Any other IA is pending?
No.
Is the matter again on?